extraterritorial application of privacy law is not, again, it's not unique to China, right? Like GDPR also has similar requirements for foreign organizations that collect personal data of EU residents. So similarly, China privacy law also adopted this approach that if a foreign organizations process personal data of people in China, or they assess the behaviors of people in China, then they are subject to China privacy law. Also, I'd like to point out that China privacy law still focus on the data activities within China. So that is also related to China's approach on cyber sovereignty and data sovereignty, because they want to exert that regulation for the things happening within their territory. That is the first point I like to point out. And the second one is regarding compliance suggestion. I think while China privacy law seems to share many GDPR elements, but evils in the details, so compliance with GDPR does not necessarily mean you will be good with China privacy law. For example, China privacy law still heavily rely on notice and consent, and there are a few additional compliance obligations, like you need to do regular auditing, and you need to do data categorization. And if you do cross-border data transfer, you need to pay attention whether your data will be subject to data localization requirement by default. You may want to design a flexible data governance plan for your data generated in China, just in case that you may be subject to that data localization requirement, not just on personal data, but potentially also on non-personal data, for example, important data, which is another concept on the China data governance region that requires data localization. And then if you are a bigger platform, for example, you run a big social media service, or you run an app store, then you are subject to additional liabilities under China privacy law. Like you need to have an independent supervisory body composed of external experts to supervise your data activities, and you need to set up a